Hello and welcome to this seminar for the East of England Energy Group. My name's Chris Grieveson and I'm one of the partners at Wikborg Rein here in London. I'm joined today by my colleague Alex Hookway, and we're going to be talking about what you do need to know and things that you need to avoid when you're drafting commercial contracts. So we'll give you some good tips on the things to be in there and some good tips on the things to keep out of those contracts. Alex, do you want to take us through the agenda?
Yeah, absolutely. So we're going to run through the basics of contract formation. Lots of people get very interested in what the contract says, but perhaps before you get to that, you need to work out whether you do have a valid contract. We're going to look at main principles of contract interpretation, so what we think about when we're drafting commercial agreements for clients. And then looking at things which do influence interpretation after the event when a dispute is on footing, and factors which courts and tribunals will take into account. And then contrasting with some of the factors which some clients may believe have some weight, but actually before the courts and tribunals have very little weight whatsoever. We then do a quick sweep up on implied terms. Often people will think if it's not expressed, but it's there, right? So we'll have a quick look at that. And then a couple of worked cases and examples just to put that knowledge into practice. So, contract formation. The top four, offer, acceptance, consideration, intentional to create legal relations, are the ones you learn in law school, and they're pretty clearly covered. You have your offer, it's accepted. I then offer consideration in form of monetary or other value, and there's a clear intention between party A and B to create legal relations. The fifth one doesn't usually turn up in the textbooks, but it is quite important. There needs to be certainty of terms. Have the parties actually reached an agreement upon which they understand themselves? So you need to run through this checklist and understand these points before you get to the contract interpretation exercise. So looking next on to the main principles of contract interpretation, I'll hand over to Chris.
Thanks, Alex. So I think one of the important things to say at this stage is that we do a lot of work in the North Sea, on the English continental shelf, and also on the Norwegian continental shelf with renewables and with the oil and gas side of things. And there's a very different approach in English law to Norwegian law, and perhaps what a number of people think about what might happen when you come to approach contract interpretation. So this is something that we're often having to sort of emphasize when we're looking at cross-border negotiations, particularly in projects across the North Sea. So main principles of contract interpretation. As one of my colleagues always likes to put it, the contract means what the contract says. And what that means in sort of broad terms is that in English law, there's a very strong adherence to looking at the words that are used in the text and trying to give those words meaning. So that's the loyalty to the text point that we have. We also look at the contract in the whole, in the round, and we look at what it's trying to achieve, and that's the so-called purposive approach. So we look at the purpose that the parties have set out to achieve if there's some ambiguity. But always what we're looking at first of all is what people wrote. In a minute we'll talk about what we're not looking at, but that's very important. The context is also important. So for example, if wording is slightly ambiguous, then you can use the contextual background in order to understand what people mean. But again, we're always primarily looking at those words. We have to look at those words too to try to make them have business common sense, but it's all about interpreting the words. And finally, it needs to be sensible. It needs to be reasonable what you're reading in to what you have in front of you. Okay, so we've just covered how we might look at actually interpreting the words of the contract. And now we want to look at 2 or 3 key points, or probably a little bit more than that, which actually are things that come up and relate to how the contract might be interpreted outside of just that pure wording that I was talking about. So we talked about the purposive approach, the commercial purpose of the contract or a specific provision just a few moments ago. Obviously, also, if there's some particularly obvious error in the contract, like there are two parties and it's very clear that party B is supposed to be performing the obligation, but it states as a typo that party A is doing that, then that sort of thing can obviously be approached and corrected after the event. Then, very important phrases which are used in contract drafting, or verbs that are very important, the verbs that are shall, will, must, may. So a lot of those words are words that have connotations that it's absolutely obligatory to do something. You shall do something, it's mandatory. Will do something, again, you're looking for those mandatory connotations there. Sometimes we have the situation where you've drafted things and there are inconsistent provisions. Obviously, you've got the classic situation where you've got a sort of pre-printed form, and then you add some conditions at the end that are added in effectively additional typing. Days of manuscript are long gone now. If you have that sort of situation, then anything that's been added above and beyond the pre-existing contract, then that will obviously, the pre-printed contract, that will take precedence. It's very important, for example, in large offshore contracts, that you'll have lots of different documents attached together. So you generally have your general terms and conditions at the sort of top of the pile, if you like, and you might have appendices which are including things like sort of technical specifications, or you might have a responsibility matrix, and typically you can give an order to the order of precedence to the documents so that you can then deal with inconsistencies between them and give precedence to the ones that are obviously higher up that list. A party can never take advantage of its own wrongdoing. So if you try to get the wording of a contract to fit a particular situation, but you've actually done something that's in breach of that contract, then that sort of kind of smart interpretation that you might sort of come up with, or you might come across an opponent or a counterparty who's saying it, that won't get any traction at all. There are all sorts of other little points that we should think about. General words at the end of a list. So you can have a number of examples that are often given in a list. And typically speaking, the rule is that where you give a load of examples, and it says, etc., or of similar type or something like that, then you're really confining yourself to the same types of examples as you've got in that list, rather than, even if you include words that suggest that it might encompass the whole world, that's not going to happen unless you go for really, really very specific wording, like any other cause whatsoever and howsoever arising. But generally, the sort of words that are intended to extend a list like that won't have that effect. Headings, often it's very clear that you state in the contract that headings are included for convenience, rather than for any other particular interpretation purpose, so that you don't get people trying to rely on headings to say, aha, this must mean the following. Alex, I think you're going to tell us about some of the things that you shouldn't do, or you shouldn't rely on,
Indeed.
or can't influence interpretation.
So commonly in certain specific sectors, in the maritime, in the offshore sphere, you have lots of discussion about, well, that's market, or that's market practice, or everybody knows that's how it's done. And this is often cited when there might be a gap in the contract, or a situation comes up which might be slightly unforeseen by the express terms of the contract, and a party says, well, in usual situations we do this, and therefore that is the contractual obligation on the parties. Now, that can work, but you need very, very strong evidence, and the courts will only accept that when it is genuine market practice, and not just the contention of one commercial party seeking to enforce a poorly worded contract. So use market practice at your peril, and only with very strong evidence. Negotiations, what came before the actual text? Chris talked about the importance of the contract is what the contract says, and that's quite right. Contracts, particularly for offshore EPC, EPCI projects, the negotiations can go on for months, if not years, and can go through huge drafting iterations with input from technical, legal, health and safety, engineering, procurement, so on and so on. So the negotiations are given limited weight to the ultimate product because it's seen as the loyalty to the text of the contract. and so what happened before is of very limited relevance. The same goes with deleted text. Deleted text and negotiations sometimes come about in rectification claims, that is when there's an obvious issue that needs to be remedied after the event, but they're treated very, very small evidential weight by the courts. Precedent cases, again, we come back to the loyalty to the text. Because each precedent case as a matter of English law is built on specific terms to that case, it's often very rare that they will transfer over, even if they're from similar subject matter, like an offshore contracts dispute. What the parties say they meant, again, this is this point about, well, you know what I meant, right? Well, no, it's about the loyalty to the text, and we start and end with what the contract actually says. And the final point perhaps goes without saying, if you can't seek to use events after the contract's been concluded in order to try and justify a contractual interpretation. Some contracts, particularly in the offshore sector, can run for many, many years, and there's plenty of events that are unforeseen at the time of contracting, and so this isn't an argument with any real weight. So we turn to the sweep up on implied terms. Implied terms, quite a dangerous subject area. So these are terms which there's a gap in the contract. It might be a gap in contractual obligations, it might be perhaps a gap in fact. And the courts are able to imply both. Facts are generally less contentious. When it comes to contractual obligations, that's when the disputes tend to arise. So courts and tribunals might imply a term into the contract on the basis of usage or custom, again with strong evidential basis. The parties' previous course of dealings, if you've got parties that frequently contract together on similar subject material or similar transactions, the intention of the parties, this is for your term in fact, to make the contract work. Was it intended that a factual statement be included in that contract? Characteristic terms to make it work, the sort of employment contracts are a good example of that. And by statute, particularly with things like business-to-business contracts, we think about sale of goods, 1979, bringing in those obligations. Now, persuading a judge or an arbitrator to imply a term has got significantly harder in recent years. That's the M&S and BMPP case of 2015. And that has shown that the courts it's the other side of the coin with the loyalty to contract. Courts are reluctant to imply terms because of the reliance on the whole contract approach and the loyalty to text. If you start implying terms too freely, then that undermines the other half of the contract interpretation exercise. And it's fair to say that when we are drafting contracts, we often look expressly for whether implied terms are excluded or whether we want to exclude them to achieve our party's ultimate goals. Okay, so we turn to a few worked examples, and these examples are drawn from cases which came before the highest courts in the land in the last couple of years on contract interpretation. So, basic fact pattern: seller of an insurance broking company appealed against a decision concerning the interpretation of an indemnity clause in an agreement for the sale of the company to the respondent buyer. The parties had entered into a written agreement for the sale of the company. Under a fairly standard indemnity clause, the seller agreed to indemnify the buyer in respect of various claims, damages, costs, charges, expenses, claims or complaints registered with the Financial Services Authority or other regulator pertaining to any mis-selling or suspected mis-selling in the period before the sale. Shortly after the purchase, company employees alleged that the company had mis-sold products to customers. The buyer informed the Financial Services Authority, which directed it to pay compensation to affected customers. The buyer then sought to rely on the indemnity to recover its losses. But could it? Okay, well, we're looking at, start with our loyalty to the text. I think the key part is made by the company following and arising out of claims or complaints registered with the Financial Services Authority or other regulator. But the complaint arose when the buyer themselves informed the Financial Services Authority. This is not something that was reported to the Financial Services Authority by the seller themselves. So the Court of Appeal took the view that actually the indemnity did not apply because the buyer's losses were actually because of the buyer's referral rather than the seller's referral. And so actually this indemnity clause did not cover it, which you may think from a reading of the contract term, might think on a plain reading, it's obvious it must have been called, but actually it was following the difference being that because the buyer had made the referral, that was key and that was not covered in the terms of the indemnity. So we turn to another worked example. This one, the fact pattern in a way is almost unbelievable, but it's very much of its time. So we have, this is a property case where 21 lessees hold 99-year leases of chalets in a leisure park owned by the respondent landlord. There were 91 chalets on the site, 21 leases in question being granted between 1977 and 1991. So these are quite historic documents, and the importance of that comes through. Each contains a covenant by the lessee to pay an annual service charge under clause 3.2. Although clause 3.2 varied slightly across the 21 leases, the lessee typically covenanted to pay a proportionate part of the cost of providing the services, expressed to be £90 in the first year, and then rising by 10% each year thereafter. 10% each year for 99 years. Although clause 4.8 required all the leases to subject or identical or similar obligations, the leases of the other 70 chalets, which had been granted before 1977, were subject to a service charge increase of only once every 3 years. So the issue was on the true construction of clause 3.2. Did it provide for a fixed service charge of £90 with a yearly increase of 10%, or whether it actually meant that the lessees had to pay a fair proportion of the cost of providing the services, up to a maximum of £90 in the first year, that maximum figure rising by 10% each year thereafter. Now, the Court of Appeal said the words were quite clear in clause 3.2. It said rising by 10% each year. Now, I looked into the facts and worked out the calculation, but that actually meant for a lease granted in 1977, the £90 charge a year rose to about £500,000 a year by 2020. But the court said the loyalty to the text was clear. It was going to be 10% on £90 every year, and that is what they signed up for. And when you looked in the context of the agreement, in the 1970s when this was agreed, inflation was running at about 10%, so it wasn't an unreasonable or illogical term to cover future costs. When someone took a lease in 1977, they accepted the risk that inflation may fall and costs may not actually reflect the charges incurred. But another example of the loyalty to the text and the importance of starting and finishing with what the contract says. And I think with that brings us to any concluding remarks that we have on that.
I'll never buy a lease in a leisure park without paying very careful attention to what it says in the contract. I think they found a way around it ultimately,
In the end,
by another route. So it's always happy to know that sometimes justice can be done. But a lot of money would have been spent going to the Court of Appeal to trying to find out what that clause meant. And I think that's the key thing. If you can try to get your drafting as clear as possible, and think about the most pedantic person that you ever can reading the wording of what you've written, that will probably save you a lot of time and money. And of course, we're always very happy to have a look at it for you if that's something that you would like.